What's up, YouTube? Welcome back to another banging video. And today we're going to be going over chapter 9, which is basically just taking everything we learned from the past chapters and putting it all together. And we got two examples for us in this chapter. Alright, so first we're going to go over the first one. Opposing a Rule 15a motion. So first we got the problem, alright? So the plaintiff claims she was fired because of her gender. And now she wants to amend her complaint to add new causes of action based on fraud and breach of contract. We're repping the defendant, alright? And our objective is to deny the plaintiff's motion to amend her complaint, right? And so then we look at the facts. That's our next step. Well, she was fired after 18 months from the company that we're repping because she was, quote, incompetent. And she filed a suit 3 years ago for gender discrimination, and both members, both parties, finished their discoveries, and now she's like, actually, I want to add on, I want to amend it. And her explanation: further review of the law shows the plaintiff has additional claims. So, nothing, a whole lot of nothing. And so then we get into the law. That's where we want to go. So first, we find out generally the conditions under which plaintiffs may amend their complaints. And that brings us to Rule 15a, right? And then second, we find similar cases, which we find Foreman v. Davis, which gives us reasons to deny, like undue delay and prejudice. And then Manzali, I believe that I'm saying that right, versus, I abbreviated it, so I have no idea what this is, CIR. And I quoted, may be denied where no excuse for delay and opposing party would suffer prejudice or inconvenience. Oh, so yeah, now we're gonna try and prove that. We have our test. I'm pretty sure that's what it would be called. So then we have to elaborate the key terms. We have to what's a valid excuse? Well, neglect isn't a valid excuse. We found in Hayes v. I abbreviated that as well. NEM. And then prejudice. And we don't really have to go and find prejudice in law because it's right there in front of our face. Our company would have no time to prepare a defense, and time and money for a new discovery would have to be spent. So then that brings us to our argument. First, our alignment. We oppose the motion, right? Get that out the way. Second, the legal principles. We have Rule 15a, interpretations from the Supreme Court and the First Circuit courts, because that's the jurisdiction that we're in. And then we have third, we're going to generate our presumptive positions. So we have P's motion must be denied. Or what's another one I wrote down? Rule 15a requires denial of P's motion, right? And so then we discard our bad positions, which from that set I just gave us, we didn't really have any bad ones, any glaring issues. But we're just going to use the first one I said. Therefore, this motion must be denied. We put our presumptive position, and we make it a conclusion. Alright? And then we fill it in with premises. Alright? So first we have our major premise, which usually involves a rule of law. Rule 15a, motion to amend a complaint, must be denied if 1, we have our test, the plaintiff has offered no excuse for delay, and 2, the adverse party would suffer prejudice, right? And then we have our minor premise, which usually brings in evidence and stuff like that. The P has offered no excuse for delay, and the adverse party would suffer prejudice, you see, following that test. And then we have our conclusion, which I already stated. Therefore, this motion must be denied. Alright, now we have to ground what we just blurted in the syllogism. Brain fart. So first we ground our major premise. That was grounded directly. All we have to do is literally cite Rule 15a. Alright? Now what gets tricky is grounding the minor premise, alright? So usually you want to start defining your legal terms. So first big ones we want to focus on is excuse and prejudice, alright? So first we have excuse. That's to an To assert an excuse for delay in filing an untimely motion to amend, the plaintiff must show a valid reason for neglect and delay, which is quoted from Hayes. The plaintiff hasn't done that. So therefore, the plaintiff has offered no excuse for delay. Boom, syllogism made. Now, we should define the word valid reason, but the P hasn't given any, so just say that. Oh, I'm running over time, so maybe I'll just go over this one. One example. And then next, the P hasn't shown any valid reason for neglect and delay. And we just cite that from the plaintiff's motion to amend the complaint. See how easy that was? Yeah. Now we have to ground prejudice. Which would be also easy to see. The defense would suffer prejudice by being forced to defend new claims after the close of discovery. And then, for a minor presence in that grounding syllogism, defendant would have to defend her claims after the close of discovery. Therefore, they would suffer prejudice. See, it's kind of easy. This example is really easy. And then we would ground new claims with the plaintiff's motion to amend. And then we get into the other one, which is the Endangered Species Act, which is basically, let me just break it down so you know I read it, which is basically just talking about this company, I'm pretty sure. They want to build like a dock, right? They want to build a dock, and it would destroy the sturgeons, like this Gulf sturgeon's habitat, and we are the, who are we actually? We're like some, like, environmentalist society, agency, I don't know, something like that. And we bring a lawsuit against them. And basically, we just go into law again to find out legal terms, to find cases that relate, and then we get into our syllogism, and we just say, the ESA prohibits a take, which we got that from the law, a take of illicit species, and then a minor premise, constructing the pier would take illicit species. Therefore, the ESA prohibits the pier. And then yeah, we just ground it. We ground take what that means. We cite law, and then we define harm because that we said that in our syllogism, which we would also cite more law, and we would define habitat and modify, which that gets into like, let's say it's because he said the book said like, let's pretend that this wasn't like listed in law or whatever, then you have to use reasonable like common sense things like that. And then after that, oh yeah, like what I just said, it wasn't coming to me, brute facts. You have to use brute facts to define something if you can't find it in law. And then, yeah, you just define the rest of your minor premises. And that's, like, a really quick summary of that. And then the last, like, mini chapter thing inside of Chapter 9 was troubleshooting. If you're having troubles beginning with an arguments procedures, just hop in somewhere where you already know the answers to and build from that. Thank you for coming to my TED Talk.